My name is Austin Gergen. I'm president of the Federalist Society. Before we get started, I do have a couple of announcements to make. First, we're going to be hosting an election reception on November 5th. It's election night, obviously.
Ooh.
And that will be taking place from 5 to 7. If you're interested in the details, check our group me, and we'll have more information for you there. Following that, the Lawyers Chapter is going to have a social hour in the near future. We aren't sure on a date yet, but that would be a great opportunity for you to meet local lawyers in the area. And then finally, there's a class immediately following this at 12:50 or at 1 o'clock. So we're going to aim to get out of here at
Leave
12:50.
quickly, as they say.
And if you could refrain from leaving early, we do plan on you being able to leave in time for your next class. We would appreciate that. And then just as a reminder, the Federalist Society is a nonpartisan, conservative/libertarian organization dedicated to freedom, federalism, and judicial restraint. The Federalist Society seeks to educate the community through its programs and publications about how limited constitutional government, based on the rule of law, can have a positive effect on law and public policy. For more information on how to join our organization, please come up to me after the event, and I'll be glad to get you that information. And then without further ado, I'd like to introduce Professor Blackman. He's a national thought leader on constitutional law and the United States Supreme Court. His work was quoted during 2 presidential impeachment trials. He has testified before Congress and advises federal and state lawmakers. He regularly appears on TV, including NBC, CBS, Fox News, BBC, and ABC. He's a frequent guest on NPR, and he has authored 3 books. One of those books is the Constitutional Law book that Professor Reynolds uses in his book.
I'm flattered.
And with all of that, I'll turn the table over to him.
Thank you so much. All the errors my co-authors in the book, by the way. Thank you so much to the Federal Society, Professor Reynolds, for joining us today. I've not been here in about 7 years or so. It's been a while, so it's good to be back in Tennessee. The Supreme Court is in a bit of a flux. For almost 2 decades, the court was the same. After Justice Breyer's confirmation in '94, there were no new members of the court until Chief Justice Rehnquist and Justice O'Connor were replaced by President Bush. But that kept the sort of equilibrium of the court about the same. That is, you had 4 fairly liberal appointees, you had 4 somewhat conservative appointees, and you had a judge in the middle who was Justice Kennedy. And then for several years, Justice Kennedy was sort of the swing vote. He was the center of the court. You had some more changes. Justice Kagan replaced Justice Stevens. Justice Sotomayor replaced Justice Souter. But again, the court stayed more or less static. But things would change significantly in 2016 when Justice Scalia suddenly passed away on the eve of the presidential election. In many regards, President Trump's election was a referendum on the Supreme Court, and he pledged to appoint someone who was conservative to replace Justice Scalia. Now, I thought, and perhaps many of you thought also, that Hillary Clinton would win the election, and she would appoint someone to the left of Justice Scalia, and the court would be kind of left-leaning for the first time in a long time. But as history turns out, in 2016, Trump prevailed, and one of his first actions was putting Neil Gorsuch in the Supreme Court. Now, swapping Scalia for Gorsuch more or less kept the court in the same place conservative was, a 5-4 court. But the big Justice Brett Kavanaugh. Now, this, in many regards, moved the court much to the right. Kennedy was kind of a swing vote with sometimes conservatives, but Justice Kennedy was at least Justice Kavanaugh, a really reliable conservative vote. So that put a solid 5-4 court on the docket. But then in September of 2020, again on the evening election, we had another vacancy. Justice Ruth Bader Ginsburg died barely 2 months before the election. I'm sure she was trying to hold out, but nature did not allow her to. And one of her last wishes, she said, was that President Trump would not appoint someone to replace her. That wish would not come to fruition. In the span of a few weeks, Trump rushed through Justice Amy Coney Barrett to fill Ginsburg's seat. This created a 6-3 conservative majority and probably the most conservative court, at least since the New Deal, if not before. About a year later, Justice Breyer stepped down and President Biden replaced Breyer with Justice Ketanji Brown Jackson. So now we have this 9-member court, at least 9 members for now, that at least on paper looks to be fairly conservative. But if you actually look a little more closely, that record doesn't quite stand up. Now, to be sure, the courts reach conservative decisions on abortion with the Dobbs case, on the Second Amendment, Bruin, on religion, Kennedy v. Bremerton. These were all cases where the courts sort of moved beyond fairly long-standing principles. If you look more closely, it's not really a 6-3 conservative court. It's what I call a 3-3-3 court. That there's three blocks of justices who often sort of take different positions. So on the one side, you have the court's three most conservative members. That is Justice Thomas, Justice Alito, and usually Justice Gorsuch. I say usually because occasionally he deviates, but for the most part, he's fairly conservative. These members will more likely than not vote together in most cases and take the more conservative position. On the other side, you have Justices Jackson, Justice Sotomayor, and Justice Kagan. These are the court's three progressives. They rarely break ranks as well. They vote together in almost all cases. There are some issues on which maybe Justice Jackson has a little proclivity on and Sotomayor, but they tend to also vote in the court's left side. But the middle of the court is where all the action is. We have Justice Kavanaugh, Justice Barrett, and Chief Justice Roberts. Chief Justice Roberts has long signaled his willingness to sort of consider, shall we say, optics when he votes. He cares very much how the court's perceived and doesn't want the court to be viewed as being too partisan. And many of his rulings, I think, reflect that. The Obamacare case, perhaps most famous, but even during the Trump years, he ruled against Trump in time after time. The census case and other pretty significant matters, and tax returns as well. Then we have Justice Kavanaugh. Kavanaugh is, and I will not pretend he's quite conservative, profoundly conservative, but he also has some institutional instincts that he cares how the court's viewed and always cares very much how people perceive him. So he'll often write these sort of concurrence, says, yes, I'm going to rule against you, but here I'm going to try to make you feel better, right? I'll say all these nice things about how important your case is, and I'll rule against you. Kind of this weird sort of, I'll make it feel okay. And then you have Justice Barrett, who perhaps is the most unpredictable of the 9 members of the court. Justice Barrett, like myself, was a law professor for many years. She was a federal appellate judge for about a year or two, very short period, and didn't do very much. And she went to the court somewhat as an open question. We didn't really know where she would fall. Increasingly, Justice Barrett is becoming someone who surprises, and not always in a way that conservatives might be pleasantly surprised. Justice Barrett rules with the court's 3 liberals increasingly, not often, but increasingly. And even though I think she's a careful originalist, and she tries to be that, she's very cautious, very hesitant. And she requires a lot of information when she goes forward and makes a conservative ruling. So in any given case, even though you have 6 conservative justices, 3 of them are in play. And in the last 2-3 years, this has not been a case where this sort of MAGA court, as some people call it, has ruled in case after case to the right. There are many cases where conservatives have been disappointed. And just as a point of contrast, I live in Texas. My beloved Fifth Circuit gets reversed on a fairly regular clip. If you want to see what President Trump could have done, look at the Fifth Circuit. And had those members been on the Supreme Court, we'd have a very different republic at the moment. So I want to walk through some of the cases that were decided last term, that's in 23 term, and I'll give a preview for the current term, that's the 24 term. The court had a healthy diet of First Amendment cases, free speech cases, and several of them involved social media. Murphy against Missouri involved jawboning. You know what jawboning is? You've never had this. Sometimes someone from the government calls, hey, you know, I saw you wrote this. That was maybe not such a good idea. Maybe you should think about doing something else. Oh, no, you don't have to take it down, but maybe just think about it some more. When you get these phone calls, you tend to respond because government has power. During the pandemic, by the way, remember the pandemic with this thing, COVID? Remember this, right? During the pandemic, he's coughing, right? During the pandemic, lots of people put information on Facebook saying, I am skeptical of vaccines. These mask mandates don't work. This 6-foot rule is made up. COVID came from China, right? In a lab. All these were put online. And over time, Facebook and Twitter started taking down these posts. Imagine that. And when you know it, that people in the administration were calling people on Facebook and Twitter saying, you know what? We don't like these messages. We think these messages are harmful to public health. So a First Amendment lawsuit was brought against the Surgeon General, Murphy, and others, saying that this violated the First Amendment rights. The lower court ruled in favor of the claim. Supreme Court reversed. Why? Boring standing. The court held that no one had standing, that not a single person who had sued had articulated any sort of concrete injury attributable to a government figure. This was an overlistically formalistic reading of standing law. I am not a fan of this decision, and the court didn't even hint at whether this jawboning was constitutional. The next big free speech case is net choice on social media again. When you know it, social media companies take down posts, so the state said, no, you cannot. Texas and Florida put a law restricting the power of social media companies. Again, this case was unanimous in favor of the social media companies, but there were very sharp breaks. They all agree that this challenge is not proper because net choice brought was effectively a facial challenge. Is they come back with an as-applied challenge. But they disagreed on the free speech issues. Justice Barrett, voting with Justice Kagan, said, no. Free speech, social media companies are free speech. Justice Alito, Thomas, Gorsuch said, no, these aren't free speech entities. These are common carriers. There's no difference between Facebook and the phone company because they can tell them what content to carry. This issue did not resolve. It will come back to the court. Okay, let's go into administrative law and separation of powers. CFPB versus Community Financial Service Association. This case involved the Consumer Finance Protection Bureau. This is a very powerful agency you may have never heard of, but they can regulate almost any facet of the financial industry. What's unique about this agency is their budget. They don't have to go to Congress every year to ask for money. They have effectively a permanent appropriation where the director can say, here's how much money I want, and he gets it from the Federal Reserve. There's no check on their budget. There's some ceilings, but it's a pretty broad budget. A suit was brought saying this violates the Constitution's appropriations clause that the executive must appropriate for a limited period finances. They lost 7-2. The court said that this is okay, that these open-ended appropriations date back to the founding. Go away, conservative litigants. Another admin case was SEC versus Jarkisy. The Seventh Amendment guarantees the right to a jury trial. What if you're an administrative agency like the SEC? They said, no, you can come to our own judges, these sort of in-house ALJs, administrative law judge. No jury, you don't get a jury, but we'll give you a fair judge who works for agency. The Supreme Court says, no go, that the Seventh Amendment right applies, and you cannot force someone to hear a case within these sort of in-house courts. But perhaps the biggest admin case from last term was Loper Bright. Do not call it Loper. Loper Bright's the name of the boat. Loper Bright, it's a boat. Don't call it Loper. Loper Bright concerns Chevron. Okay, so what is Chevron, dearly departed? Chevron was a case from 1984 which held that if there's some regulation and it's ambiguous, we're going to defer to the government, right? The government says, here's what this reg means. We're going to defer to you if it's ambiguous. The upshot is that in any case where they find ambiguity, and there are a lot of those cases, the government wins. It's very hard for the government to lose with the Chevron doctrine. Initially, this was a conservative doctrine because the Reagan administration didn't want judges in D.C. second-guessing it. But over time, liberals came to love Chevron. It's like, wow, we can uphold every regulation in the world. This is great, right? Whatever environmental stuff, great, we uphold it. It became unpopular on the right, and there was a decade-long movement to reverse Chevron, and that finally culminated in a case called Loper Bright. Chief Justice Roberts, for the majority, said that the courts have to decide de novo questions of law. We cannot put our thumb on the scale on the side of the government. We must treat all sides fairly. Justice Thomas concurs, says, yeah, I'll raise you one. Chevron's unconstitutional. That violates the due process of law to give the government the benefit of the doubt, that the burden should be on the government, not on the individual. Justice Kagan, who was an admin professor, was basically in mourning. She was sitting Shiva for Chevron. She was very sad. That one, right? And she said this is a judicial overreach, and it's a transfer of power from the elected branches, Congress and the executive, to the courts. How much of an impact Loper Bright has, TBD, I don't know. I think judges will kind of ignore it like they ignore Heller. Mr. Reynolds might speak to that in a few minutes. We have the Second Amendment. But I think we'll see a Loper Bright become the new basically Heller. That's my short take. Okay. So that's guns some more. Bump stocks. Garland versus Cargill. This is not a Second Amendment case. It's an admin case. So what is a bump stock? Okay, I've never used one, but you can look them up on YouTube. It's a device you can put on a rifle. You basically mount it to your shoulder. And if you pull the trigger once, the gun sort of lurches forwards and backwards on this little thing on your shoulder, such that your finger keeps pushing the trigger over and over and over again. It's not a machine gun. In fact, it was designed to not be a machine gun. The statute says the definition of a machine gun is where more than one bullet comes out with a single function of the trigger. That's the word, a single function of the trigger. With a machine gun, you pull the trigger and it sprays bullets. Here, the gun goes back and forward, such that your finger keeps going back and forward. You pull the trigger one per bullet. Okay. The Trump ATF, again, this is not Biden, this is the Trump ATF said, aha, we need to ban bump stocks. This was after a mass killing in Las Vegas where a guy was in his hotel window, started shooting people. It's an awful, awful thing. But Congress never enacted a statute. So Trump said, aha, we will take this old statute and clarify it and interpret it. I had filed amicus briefs against the Trump administration. That's something I did very often. Actually, I did a couple times. This is one of them, saying that this was an unlawful rule. Fifth Circuit ruled in favor of the gun owners, and the Supreme Court affirmed. The court said this phrase, single function of the trigger, means you pull the trigger. If this little device makes the gun go back and forward, there's one bullet per function of the trigger. This, I think, was actually not a very hard case. It still split 6-3. I think, in my view, if the Congress wants to ban something, they should try and pass a statute. You should not have the executive branch try to reanimate decade-old statutes into new purposes. Don't pour new wine into old bottles, as the saying goes. All right, let's K on guns. U.S. versus Rahimi. All right, so brief background, I'm sure you'll know this. D.C. v. Heller, 2008, held that the individual right to bear arms that is not connected with militia service. About 2 years later, you have McDonald v. Chicago, which incorporates the Second Amendment. And then in the 13 years between McDonald and Bruin, there were no major Second Amendment cases decided. You had some smaller stuff about stun guns and some other random things, but the court denied every single gun case. Finally, you get New York versus Bruin. Okay, this involves, is there a right to carry arms outside the home? Again, it says to keep and bear arms. Bear seems to mean carry, at least in my view. And the court said, yes, you have a right to bear arms outside the home. But Bruin didn't settle another issue. What about disqualified persons? Okay, you ask, what's a disqualified person? Under federal law, if you are a disqualified person, you cannot have a firearm. And there's a lot of ways you can become disqualified. If you are a felon, you can be disqualified. Also, under federal law, if you're subject to a domestic violence restraining order, DVRO, domestic violence restraining order, you cannot bear arms, you are a disqualified person. These DVROs are issued often ex parte, usually in family disputes, often with custody disputes involved. And when you're subject to this order, you cannot have a gun. Hello, Zaki Rahimi. This is not a good dude. He is a bad dude. He shot at his girlfriend. He shot at people. He shot up a burger joint. Shot up a Whataburger. He shot everyone. He didn't actually hit people, which I still don't understand. He shot lots of people. This man should be in jail. I am the second biggest second advocate in this room, right? Usually I can say that, not with this room. But Zaki Rahimi should not be living on the streets amongst human beings. He should be in jail for a very long time. Yet he wasn't incarcerated. He was not indicted on charges. He was only given this restraining order. What happened? He kept his gun and started shooting at people again. So then the feds nabbed him on section 922G8, which says you can't have a gun if you have these orders against you. Initially, he lost. After Bruin, the Fifth Circuit reversed and let him out. They said your sentence has to be vacated, for at least for now, and it goes to the Supreme Court. Rahimi lost by a vote of 8-1. This one wasn't even close. Now, we could put the Second Amendment aside for a minute and say, okay, did the Supreme Court justices really want to give a gun to a guy who shoots at his girlfriend? No. These are, as we say, bad optics. Only Justice Thomas was in dissent, and Thomas said, wait a minute. I wrote the Bruin decision. I wrote it. I know what it means. You guys are deviating. Want to know something? Thomas is right. Chief Justice Roberts and Rahimi walked back Bruin. In fact, he may have diluted it significantly. That's how you get to this ruling. I think this will undermine Second Amendment litigation for years to come. Indeed, in the wake of Rahimi, lower courts have started going back to the old way, say, okay, yeah, we're just going to defer to the government. And yeah, there's some tradition of a similar gun law close enough. Yeah, we can ban magazine sizes. We can ban you carrying guns in a park. Yeah, we can declare all of Manhattan a gun-free gun-free zone. No big deal. So, Professor Reynolds and I've been writing about the Second Amendment now for many years, and it's kind of just ebbed and flowed. And I worry that Rahimi will sort of set back the movement for some time, but we shall see. All right, enough about controversial stuff like guns. Let's talk about abortion. Mifepristone. What's mifepristone? It's a pill that women can take that can induce an abortion. Okay, the FDA approved it some time ago, and over the years they've made it easier to get. For example, you don't need to go in person to a doctor. This is a COVID measure. It can be mailed to you, and so on. A group called the Alliance for Hippocratic Medicine sued, and they said that the FDA process approving this drug was not valid. They request a lot of relief to even take the thing off the market, or at least to make it harder to get. Fifth Circuit ruled in favor of this group. Supreme Court reverses by a vote of 9-0, another unanimous reversal, although it's not as bad as it seems. I'll explain why. Again, this is Justice Kavanaugh on standing, saying that this group cannot show an injury. Who are the plaintiffs? These were doctors who said that we think that if this drug is in the market, women may have complications from an abortion. They'll come to us, require treatment. And the court said that is far too attenuating. Do not get standing. Even Justice Thomas voted to reverse. Although, just to defend the Fifth Circuit briefly, the case changed a bit. One of the issues was whether these doctors would be forced to perform medical procedures related to abortion. In the lower court, the doctor said, we have religious objections. And the government said, too bad. Even if you have faith objections, you still have to do the abortion. By the Supreme Court, they changed it. No, you do not have to perform the abortion. Well, that changes the case, right? Now, you have to perform the care related to the abortion. That changes the case. So the case changed on appeal. Another abortion case, Moyle versus U.S., M-O-Y-L-E. No, not that Moyle. We talk about Shiva to circumcision. This is M-O-Y-L-E. Moyle versus United States was a case about EMTALA, the Emergency Medical Treatment Act, EMTALA. This law says that if someone shows up at an emergency room, you must provide stabilizing care. What if a woman comes up to a hospital and says, my stabilizing care is I need an abortion? Doctors in Idaho perform the abortion. So the question is whether Idaho's abortion ban was preempted by EMTALA. Again, the Supreme Court didn't really resolve it. They sort of dismissed it. But there were all these opinions flying this way and that way. What's important to recognize, though, is that earlier in the litigation, the government's position was, even if you have a faith-based objection, you still have to perform the abortion. And now the government said, no, you don't have to perform the abortion. So again, the court was reversed, but the case changed. And when the case changes in appeal, it's sort of harder to blame the lower court. All right, take your time. Eighth Amendment grants path. This is an unusual case. So it involves people who are homeless. And grants pass made it a law to say that you cannot camp in public. Camp. What does it mean to camp? To lie on a bench, to lie on the ground, maybe with a blanket. Now, if you don't have a house and you have nowhere to go and you're tired, what are you supposed to do? I mean, it's actually a very hard question. You have nowhere to go, you have no home, and the government comes and gives you a ticket for sleeping. So the question was, does this violate the Eighth Amendment? 6-3, the court says no, that the Eighth Amendment has nothing to say about this issue. There's a long tradition of banning public camping. This is not cruel and unusual punishment. It might be a due process violation that wasn't presented here. Okay. Let's do Trump cases. So there were two major Trump, no, there were more than two, but there were at least two major Trump cases last term. First, involving insurrection. Everyone remember that? We had a thing insurrection. I did a lot of work on this case last year. So the argument was that Trump's conduct leading up to and including January 6th was him engaging in insurrection, and all of his supporters were insurrectionists, and the January 6th Capitol thing was insurrection. Therefore, Trump should be disqualified. Now, I filed many amicus briefs. I think that argument was wrong. The Supreme Court ruled 9-0, unanimous, that Trump should stay on the ballot. The reasoning was not entirely satisfactory, but the upshot is that the states do not have the power to take him off the ballot. But this leaves open the issue. What about Congress? So we have an election coming up in, about a week or so, right? Let's just say Trump wins, and let's say that Democrats win both chambers of the Congress, House and Senate. And let's say a majority of the Democrats in Congress say, Trump, you are disqualified. We're going to vote for Kamala. It could happen. Look, all I'm saying is things can get wild depending on what happens next 2 months. You give a situation where I have President Tim Walz if they don't certify a president. If neither Harris nor Trump qualifies on on the election anyway. So lots of weird stuff. You have President J.D. Vance. Lots of weird stuff can happen. But the Supreme Court's decision to not resolve the insurrection issue leaves all this open. Okay? Perhaps the biggest case of the term was Trump versus United States. And this involves the issue of presidential immunity. Now, the Supreme Court long ago held that the president has civil immunity, that is, you can't sue a former president for actions within his sort of perimeter of duties. You can't do that. That was a case called Nixon against Fitzgerald. But the court never had to resolve the issue of criminal immunity for an obvious reason. Presidents were never indicted, right? It's just sort of former presidents were not indicted. There was a reason why you don't have to resolve it. But hello, Jack Smith. So Jack Smith indicted Trump in several courts, and the issue is whether Trump was absolutely immune. So the court rejected the argument for absolute immunity. They said no. But by a 6-3 vote, 6-3, 5-4-ish, the court said that we are going to largely give Trump immunity. So that there's certain actions within the president's core, those are immune. And even the court's liberals agree on that point. And there's certain actions that are clearly private. Like if Trump just goes to Fifth Avenue and shoots someone, that's not presidential power. Okay, that's not immune. But then there's kind of this murky middle where you're not really sure where you are, right? The court analogizes the young staff from Justice Jackson's zone of twilight. Right? The zone of twilight. He likes Justice Jackson. So the zone of twilight. But the rub is it's presumptive immunity. In other words, if it's not clear, the presumption is this is immune. This case caused a lot of outrage, a lot of sort of controversy. I don't think it's going to last an impact. Look, if Trump wins, the prosecution is frankly over. If Trump loses, this probably goes to a trial, maybe next year. This trial could take a year to plan, maybe a year to hold. In normal course, criminal cases take a very long time to take to trial. And once he's in office, there's no more urgency. There will be appeals. He'll probably never see the inside of a jail cell. So I think it's largely just for show. I don't know what this will affect for future presidents, but I think this probably will not have much impact on Trump himself. Okay. That is the end of the last term. Let me run now to the current term. Now, what's sort of curious about this term is it's very quiet. The court hasn't granted many big cases. In fact, to look at the cases for October, November, and December, there's almost nothing big. I'll talk about, but nothing big. The theory or the thinking or the scuttlebutt, if you will, is the court is clearing the deck. You're saying, okay, we have an election coming up. We don't know what crazy stuff's coming from the states. Let's just go easy on the actual real law, and let's just keep ourselves some time to figure this stuff out. You don't want it to deal with like a Bush v. Gore case with all these other important issues. So there's not too much big stuff on the docket. I'll walk through some of the important cases. One case that I've been involved with is Garland versus Vanderstock. I'm actually one of the lawyers in this case. This involves so-called ghost guns, a phrase I don't like very much, but it's one that's people using it. This involves guns that are generally made at home, do not have serial numbers. They're probably not made of plastic, although perhaps they could be 3D printed. But the key issue is they're not made with serial numbers, and you need no background check to obtain one under federal law. For the longest time, people were making guns at home, going back to the American Revolution. In the woods of Kentucky and Tennessee, people were making rifles for a very, very long time. Okay, trust me, this happens. Even to this day, if you want to mill your own AR-15, you can do that. You can drill a hole here, drill a hole there, make your modifications, and you have a fully functional firearm. The Biden ATF said no more. We need to treat even a gun kit as if it's a firearm. That is, the kit to make the gun, the unassembled part, is itself a firearm, which requires a background check and other types of requirements and registration rules. The Fifth Circuit ruled against the U.S. government on appeal to the Supreme Court. So I'm one of the lawyers in this case, so I will avoid commenting on it, but you can look at the arguments. We'll see what happens. Okay. Another big case this term is Glossop versus Oklahoma. This involves a death penalty case. Now, Glossop had been to the court before on an Eighth Amendment claim, saying that the execution protocol was cruel and unusual. He's back, this time under Brady against Maryland. But this is an unusual case. Usually, the defendant says, you didn't release this evidence, overrule my conviction. And the government says, no, there's no Brady violation. But this is a weird case where the attorney general came in and said, I'm confessing an error, that there was some document that should have been disclosed and we didn't disclose it, and I want to vacate the conviction and retry you. That never happens. But what makes it more curious at the court is the court appointed a lawyer saying, no, we're going to defend the judgment. In my view, there was no error. I think that the document that supposedly was hidden has no materiality, and it doesn't actually prove what the government says it proves. So this might be a weird case where there's no clear ruling. Why? Gorsuch is recused. It's an 8-member court. This one might go 4-4. What happens if it's 4-4? You affirm the Oklahoma court, and the death sentence stands. There's still clemency. You can seek pardons from the governor and the other processes. But I think it's hard for the court to rule in favor of the defendant. All right, medical marijuana versus Horn. This is kind of a, I don't want to say fun fact pattern. So you have a truck driver who has some back pain from a car accident. He takes some CBD. And on the CBD, it says in big letters, there's no THC in here. That's important because he's a truck driver, and truck drivers have random drug testing. But when you know it, he's taking this product that says no THC, which is the active ingredient marijuana. He fails his drug test. Turns out there was THC in there. Go figure, right? So he brings a lawsuit against this company called Medical Marijuana. But he uses a different statute. He brings civil RICO. You ever know about civil RICO? You all know about RICO criminal. That's like organized crime and mafia stuff, right? This is civil RICO. They basically alleged that this company was involved in this racketeering campaign of promoting their product as THC-free when in fact it had a controlled substance in it. So the issue is whether you can use what's effectively a personal injury under the RICO statute. This one is close. I think the truck driver probably loses this one, but I think it's actually a very hard issue. Usually RICO is not for slip and fall torts, and it's sort of hard to distinguish slip and fall torts from what's effectively a personal injury that you took a drug that you don't want to take. All right. Another case this term is called, what's the big one? Scrimeti. Oh, I'll talk about Scrimeti for a minute. We're in Tennessee. Okay, actually, I'll spend some more time this one. So the Supreme Court's approach to gay and lesbian people has been sort of unexpected. I'll describe it like this. In 2003, the court decided Lawrence against Texas, right? That court held that there's a violation of the equal protection clause, or of the due process clause, to punish people for engaging in homosexual relations. That was a 5-4 case. Actually, it was 6-3 because there was O'Connor still there. And the court overrules Bauer versus Hardwick. About a decade later, the court decides United States against Windsor. This declared unconstitutional the Defense of Marriage Act. DOMA was a federal law passed during the Clinton years, which said for purposes of federal law, marriage is one man and one woman. Again, Justice Kennedy wrote the majority opinion in the Windsor case, finding both the violation of the Fifth Amendment due process clause and the Fifth Amendment equal protection clause, which it's not really there, but go with it. There's like a protection clause, Fifth Amendment. Just go with it. Again, there's a violation of the dignity of these various couples, and that Congress had no power to set these relations. 1 year later, or 2 years later, the court decides Obergefell v. Hodges, which also came in part from Tennessee. Obergefell found a right to gay marriage under the due process clause of the 14th Amendment. Again, it was not equal protection. This created this kind of oddity that under federal law and the federal constitution, gay couples had a right to marry. But under Title VII and discrimination laws, you could discriminate against a gay person. Hello, Bostock. So in 2000, in 2020, the court decides Bostock v. Clayton County, Georgia. And here we have a majority opinion by Justice Gorsuch, one of the Trump judges. And Chief Justice Roberts joined, saying that Title VII, enacted in 1964, bars discrimination on the basis of sexual orientation and gender identity. Again, some people are surprised by this. I actually wasn't. Gorsuch had a very similar opinion on the 10th Circuit, or on the circuit when he was there, but this was not surprising. So, okay, so we kind of caught up. So you have gay marriage, and then you have Title VII, okay? The remaining issue involves transgender rights. And Scrimeti is a variation of this issue. As you probably know, in Tennessee, Senate Bill 1 prohibits all medical treatment that are intended to allow, quote, a minor to identify with or live as a purported identity inconsistent with the minor's sex, or to treat, quote, purported discomfort or distress from a discordance between the minor's sex and asserted identity. Okay. The Tennessee law is not unique. It was enacted very similar in other states. Different lawsuits were brought. The United States brought a lawsuit, as did the ACLU, right? So there's sort of parallel litigation. Okay. The Sixth Circuit upheld the Tennessee law. And both cases go to the Supreme Court. Now, the Supreme Court has a choice here. I'll just spell this out for you. If the Supreme Court grants the government's petition, there's a risk. What's the risk? Well, if Trump wins the election, the Trump DOJ can just dismiss the case and say, no, we agree with Tennessee now, go away. If they grant the ACLU petition, the case is there. The ACLU is not changing their position. They're pretty set in their views, right? And there also are two constitutional questions. The first question involves the Equal Protection Clause. Is Tennessee Bill 1 a form of sex discrimination? That is, does it treat people differently based on their sex? Tennessee says, no, we treat all male children alike. We treat all female children alike. The other side says, no, you're treating people differently based on their gender identity. Okay. There's also a due process issue that's a little bit sort of unexpected. These are not the cases where, the children want one thing and the parents want something else. In many of these cases, the parents want their kids to get this medical treatment. And the state comes and says, no, this is not safe. Parent, you go away. You can't get this treatment. Go to another state. So historically, there's been a right of parents to direct the upbringing of their children. You see this in cases like Pierce v. Society of Sisters and Meyer against Nebraska. And this is usually a conservative view that parents should have the say in their kids' livelihood, not the government. This came up a lot during COVID, where many parents did not want their children getting vaccines, and schools had vax mandates. They said, no, parental rights. Where's my parental rights? So here you actually have the parents of these transgender children saying, parental rights. I am the parent. I want to have the power to decide what my children get, what medical care my kids have. So both parties petitioned on the due process issue, but the court did not grant on the due process issue. They just didn't grant that question. The Supreme Court's a cushy place. They only decide the questions they want to take. So there's no actual due process issue. All that's here is equal protection. The case we argued on December 1st. I don't know which way this one's going to come out. Again, Chief Justice Roberts and Justice Gorsuch and Bostock showed at least a propensity to consider claims of discrimination against transgender people. Arguably, this is different, right? That was a statutory case. There's a statute saying you can't discriminate on the basis of sex. Here, it's less clear that there's sex discrimination because all males being treated the same way and all females being treated the same way, at least the state argues. I don't know which way Gorsuch cuts. This could be 5-4 either way. I guess we will see what happens. All right. After Scrimeti, there's not too many other big cases in the court's docket. I'm going to pause a moment to take questions or think of your questions, but I just want to just sort of leave you with this one. I stand here October 30th. Tomorrow's Halloween. Happy Halloween, everyone. Gonna go trick-or-treating soon. Halloween's tomorrow, and on Tuesday we have an election. We don't know what will come up after Tuesday. There are some hints already. There's litigation in Pennsylvania over late arriving ballots. There was some issue in Virginia about purging non-citizens from the election rolls, right? There are going to be some issues in Arizona. There are always issues in Arizona. Atlanta and Georgia, there'll probably be issues. See what happens in Wisconsin. The Supreme Court there has been an issue of some controversy in recent years about requiring the use of drop boxes, these ballot boxes. Just last week in Oregon, these ballot boxes were lit on fire. So there are a lot of sort of question marks. So I'll just leave you with one aphorism: let it not be close. That whoever wins, let the margin be sufficient enough that it doesn't come down to judges to decide. Because if it does come down to judges, well, they'll be back here talking about next week. All right. Thank you so much, and I'll welcome your questions. You can clap. That's okay. What questions? Yes, right there.
I was just wondering if you could speak a little bit to sort of in Rahimi and what was the prior?
Bruin.
There seems to be a tension amongst the conservatives about history versus text. And Justice Barrett seeming to not wanting to abandon a more technical approach, but others seeming to read in more history. What's kind of going on there?
Yes. Again, the court's conservatives don't all line up. I don't think they like each other. Did you know that Kavanaugh and Gorsuch were in the same high school? Did you know that? They were about a year apart in high school. You know, they both clerked for Justice Kennedy the same term, and they never talk about each other. They don't like each other. They really don't. And I don't think Barrett likes Kavanaugh or Gorsuch. I think they just don't like each other. They don't get along well. Ginsburg and Scalia were excellent friends. This is well known, right? I think the Trump appointees don't like each other. They're very different. They have different worldviews, and they don't try to persuade each other either. So the question I want to address, the question that was asked, what is originalism? Historically, originalism asks, what is the meaning of the text, right? Of the text that was adopted. What does bear arms mean? What does keep arms mean? But Justice Kavanaugh has it in his craw that we can't be so fixated on text. He likes what he calls text, history, and tradition. Text, history, and tradition. So again, no one has any problem with text. We all agree on text, right? And history, meaning the history before the text came, sure, right? What were the laws enacted beforehand? But the rub is the third one, tradition. And this is where Justice Barrett jumped ship. Barrett's like, why are we looking at all this stuff that happened 100 years after the text was ratified? Has that informed the meaning? Kavanaugh defends this vigorously. He says, no. That when you have a consistent tradition that informs what the meaning is. In other words, if there's a meaning and we look at what the people did, that tradition reflects the meaning. It's almost retroactive looking. And Barrett won't go along with that. Why does this matter? Of the court's current originalists, Justice Barrett requires the most persuasion to do anything. She wants it tied up, wrapped in a bow, neatly wrapped, everything perfect. And she often says the lawyers didn't make their case well enough, I won't rule for you. She's a law professor grading papers. She's not a judge, right? Just to be very clear. The same way that Professor Reynolds might scrutinize your term papers, like, no, this is not good enough. Go back to the drawing board. You will be lawyers soon. You will do your best. You can never do as perfect work in a brief as you would for a paper. You just can't, even at the Supreme Court. So I think Barrett's standard is unrealistic. As a law professor, it's not surprising, I think. But in the short run, there are going to be some cases where at the margin, Barrett and Thomas and Gorsuch and Kavanaugh are on the different pages. There's another case called Vidal v. Elster. Didn't get a lot of attention. It was an IP case where Thomas, had an opinion on the meaning of the First Amendment, and Barrett's like, "Wait a minute, that's not good enough. I'm not persuaded. I'm going with Justice Kagan instead. We're going to just make up a common law test." Right? That's the rub. When Barrett's not persuaded, she just makes stuff. Right? Kavanaugh at least is predictable. You know where he's going to come down. Barrett is unpredictable. Good question. So anyone else? Yeah, sure. Go. I'm going to lunch with them afterwards.
I'm just wondering, you mentioned that this term was not very political in nature, and part of that is because of the elections. But do you think that the conservative bloc has done a lot of the big changes it wants to do, and it's going to be steadier moving forward?
Yeah, I mean, they kind of got the big stuff out of the way, right? So in the span of 72 hours,
June of 2022, a period I'll never forget in my life. In the span of 72 hours, you have Dobbs, overruling Roe v. Wade in Casey. You have Bruin, which is a massive second opinion. And you have Kennedy v. Bremerton, which is a massive speech religion case. In the span of 3 days, we got rid of Roe, Casey, and the Lemon Test. Huge with a Y. Huge, right? Fast forward a year. Students of fair admission effectively overrules Bakke. It does. And overrules Grutter and Gratz. It does. It didn't say so, but those cases are gone. This last term, Loper Bright kills Chevron. There's not much left. Right? I mean, maybe Morrison v. Olson, maybe a couple of cases. There's not actually a lot in the chopping block if precedents overrule. You sort of have your wish list, and most of those things are gone. Then again, look, if the election goes a different way, we might have 15 justices next time I come. We'll have to learn a bunch of new names. I don't know. I'm being somewhat facetious, but not really. Once the filibuster's gone, I don't see how the court stays at 9. I think the temptation will be too strong. So be very careful when you kill the filibuster, because the court is, all the other stuff is, whatever legislation passed, that's all secondary. If they get the court, then we're heading to Mexico. You know what happened in Mexico? Mexico just changed your entire judiciary in like a very rapid period. Now they're all standing for election. If you think you can't radically change a court system in 1 minute, you can. It can be done very quickly. Very good question. Yes, in the back.
That was into my question. So if President Harris becomes president, do you think that there will be the packing of the court like she's intimated? And if so, how would conservatives or people who just are worried about the institutionality of the Supreme Court combat that?
Right. So the question was, would they pack the court? How would the response be? So the first step is they kill the filibuster, and Harris, and I think virtually every Senate Democrat has said that we will get rid of the filibuster, at least for abortion. They'll try and pass a statute that purports to reinstitute Roe v. Wade. I think that statute would probably be unconstitutional. It's probably an extension of the Commerce Clause. So let's say they pass a statute, the court declares unconstitutional. Then they'll just flip out and say, well, we tried to do democracy. Now we need to add members to the court. Or they'll do this thing by term limits by statute. I think it's more risky, right? The term limit thing, I think, it won't work. You need this amendment. But there's nothing in the Constitution about adding new justices. I think they just add 3 more, 12, maybe 6 more. I don't know, 16, 15. I think the pressure will just be too great. There's been this year-long campaign to delegitimize the court. And once that campaign succeeds, adding members to the courts is different than adding members to your local city council, just another political body. What's the response? 15 is a nice number, 18 is better, right? You just keep growing. At that point, you don't have the court. It's a farce, right? You're not actually engaging in law anymore. One idea that someone mentioned, you pass an amendment that you pass a constitutional amendment where you fix the Senate limit for voting at 2/3 or 3/5, and you fix the court at 9. So basically, you constitutionalize the filibuster the 9-member court. Maybe not crazy, but I hope President or Vice President Harris, if she wins, reconsiders. But we don't recover from that. And once you pack the court, it's over. You don't have a court anymore. Yes. What other questions you have? Yeah, in the back.
So during the COVID pandemic, one of the things that Trump touted a lot about was how the U.S. administered vaccines at a faster rate than any country in the world, and that was attributed to in part the fact that the Chevron doctrine allowed the CDC to not be impeded by challenging suits that came from that. And I was just wondering, how could maybe Chevron impede administrative agencies' abilities to effectively and efficiently control national?
I haven't heard that. How did Chevron help make vaccines quicker? I actually haven't heard that at all.
Oh, well, I just read something about how one of the things about Chevron is how it allows agencies to handle emergencies like this that are now on a national level when they're not being drowning in lawsuits or anything. They can just the government can just handle it.
Well, I mean, FDA approval in particular is not really something that's subject to review in that regard. I'm really not sure. I'm sorry. Yeah, but I think I'll answer the question more broadly if I can. I think the demise of Chevron will probably make it harder for the government to regulate in many regards. But I just don't think courts going to be in the business of second-guessing agency if they really want to. Right? The actual Loper Bright case, I didn't even mention the facts, is kind of, it's not about expert agencies. It's about imposing, here's actually the facts, on fisher boats. You have to have watchers who see how many fish you're catching of a certain size. Who pays for that watcher? the fishermen. And that person, that watcher, takes a seat on your boat that cannot otherwise be used by a fisherman. This is not about how many parts per million of a drug you need to have safety, right? This is just an issue of what's the best reading of the statutes. I think a lot of these sort of horribles about expert agency opinions won't be disturbed. It's going to be the egregious use of statutes to handle new problems that Congress want to address. That's, I think, will be the primary. But thank you for the question. All right, what else?
All right, we've
We
got
had
time for
one more question. Or no more questions. Yes, ma'am.
Any thoughts on the Purdue Pharma case?
Oh, I don't do bankruptcy. I'm sorry. What do you think about it?
I thought the split was interesting.
Justice Kavanaugh is the hillbilly elegy justice, right? He just wants people to mass. I think he was very upset by that, what the Sacklers did. But I don't go to bankruptcy, so it's not pretend to.
All right, with that,
Thank you all so much.
Join me.